Hello and welcome to the program. I am DEJI360. When the federal government announced that it will be pursuing all options, including litigations, to ensure the controversial Section 84, subsection 12 of the Electoral Act 2022 is removed, nobody thought it would be this soon. A few days after the government made that announcement, a federal high court sitting in Umuahia, the Abia State capital, has finally ordered the Attorney General of the Federation, Abubakar Malami, to immediately delete that clause from the Amendment Act. The section says, quote, "No political appointee at any level shall be voting delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election," end of quote. Now, delivering judgment in a suit filed by one Nduka Edede of the Action Alliance, seeking, of course, a proper interpretation of Section 84.12 of the new Electoral Act, Justice Evelyn Anyadike ruled that the section was unconstitutional, invalid, illegal, null, void, and of no effect whatsoever, and cannot stand, as it is in violation of the clear provisions of the Constitution. Now, Justice Anyadike further states that the Constitution already stipulated that appointee of government seeking to contest elections were only to resign at least 30 days to the date of the election, and that any other law that mandated such appointees to resign or leave office at any time before that was unconstitutional. Lawyer to the plaintiff, Emeka Ozwani, a senior advocate of Nigeria, said by the judgment, the National Assembly is not required to further make any amendments to the section. He added that the import of the judgment is that Section 84.12 of the Electoral Act is no longer in existence or part of the Electoral Act. Well, some people will call this an earth-shaking judgment. Joining me now to discuss the program, to discuss this further now, is Libros Oshoma, who is a legal practitioner as well as a political analyst. Libros, your take on this judgment by that federal high court in Umuahia?
Yeah, this is how to develop the law. And like we say in law, the law is what the court says it is. Also, coincidentally, Emeka Ozwani, senior advocate, is my friend and my classmate. We both worked in the same law firm as young lawyers together. And we used to call him Prof. He's one person that, I tell you, he schooled in Unilag, and was one person that loved to test the law and also to enhance the development of the law. The Attorney General saying that they have not taken a decision or that they are still, they are thinking of what to do. For me, it's not what an Attorney General should be saying. I had expected that the Attorney General should be telling us that they are already in court challenging such a section. And so, Emeka Ozwani, representing one Nduka of Action Alliance, had gone to court to challenge that section. And then the courts, in its wisdom, had looked at the clear provisions of Section 66, Section 107, Section 137, and Section 182, all paragraph 1F, and then says, look, this section conflicts with these other sections that I have read, and those sections clearly spells out. If you permit me to quickly read, I have my
go ahead. Go ahead.
It's almost the same thing, starting from Section 66 1F, Section 37 1F, Section 66 is on House of Rep and members of the Senate. Section 107 is for the governorship, disqualification of office of the governorship. Section 66, it says a member of the Senate or of the House of Rep shall vacate his seat in the House of which is a member if, without section qualification, Section 66, no person shall be qualified for election to the Senate or the House of Rep if he is a person employed in the public service of the Federation or of any state and has not resigned, withdrawn, or retired from such employment 30 days before the date of election. So, what the judge is clearly saying, that section is repeated in all of those other sections that I quoted, section 107, section 137, and section 182 of the Constitution, or paragraph 1, or subsection 1, paragraph F. What the section is basically saying, it has stated that a member of the public service must resign. But the question here, the big issue is, the Electoral Act extended the public service to mean everybody, inclusive of political appointees. Yes. So this matter as it is, I think the other parties will still go to the Court of Appeal, because
I want to ask you this because I'm not a lawyer, obviously, but look, this was a suit seeking interpretation. So who would then appeal against this?
The suit, when you go to courts, when the suit seeking its interpretation had sued somebody, I think it should be members of the maybe the National Assembly, the Attorney General of the Federation, and any other person that is empowered to either make law. But I really don't know who the defendant in this matter is. But it should be the Attorney General, because the order was directed at the Attorney General.
And of course, you wouldn't expect the Attorney General to appeal this.
No, but I also think that some interested parties will apply to be joined in the matter for the purpose of appealing the order or ruling of the court, because, like I said, the Electoral Act expanded the scope of who should resign. The Constitution talks about public service, and the court the Court of Appeal had interpreted a public servant to mean somebody who is employed in the service of the federal government, that ministers are not public servants for the purpose of the public service rules. And so, but lawyers also differ. And for the purpose of, determining who is a public servant, whether the Constitution covers the field in as far as the issue of public service is concerned, because the Electoral Act specifically mentioned political appointees to include those that should resign. Unlike the Constitution simply says, members of the National Assembly, talks about the governors, deputy governors, talk about the president and members of the State House of Assembly. The Constitution did not mention ministers and other political appointees. Then the Constitution also talks about, members, people employed in the public service of the Federation, and of the states. So, but the Electoral Act seems to expand that scope. The Electoral Act is also talking about people who are appointed by both the executive, who are political appointees. So I think that is the tiny, thread that is missing in all of this. And maybe,
okay, Libros, now let's even leave the issue of, the legal aspect aside. At least we now have a court ruling, which, of course, as you have said, is the law now. Let's talk about serious politics. You look at this law made by the lawmakers. Don't you think, look, this was an ambush by the lawmakers, and that this law was specifically designed to suit their own purpose, so to speak, to protect their interests, not really the interest of the country as such? Because the truth is, you look at it from the other angle, they are trying to avoid a situation where some of them, of course, who would be going to seek the nomination of their party now would not have to contest against some of these ministers, of course, who would not resign their position, would be in their position and still run against them. I mean, what do you think? What's your take?
That is just a tip of the issue. The issue is not running against a minister who still enjoys perks of office. The issue really, the fight, I agree with you that this is a fight between the members of the National Assembly, that's the legislature and the executive on who controls the levers of the party. And certainly has nothing to do with the interest of the ordinary Nigeria. what is at play here, like if you know, the governors will appoint essays to essay, essay to essay. In some cases, you have 2,000 essays.
And these essays are statutory delegates.
These essays are statutory delegates. And so, when you are running for an office, and if you are running against the governor, for example, and the governor has 2,000 essays, who are statutory delegates, and you, how many people do you have, apart from your supporters, who majority are not statutory delegates, you will pander to the whims and caprices.
So the question then, the next question then is, why are these lawmakers? I mean, rather than bring this into the Electoral Act, why are they not working with their party to change their party constitution to say, look, you know what, look, that you hold a political appointment, that you're a government appointee should not qualify you as a statutory delegate. Why are they not working to change that?
DEJI, it is not that easy, because the people that you are working to change the party constitution are the people who want to perpetuate themselves in office. And so the only way you can fight that battle is to use what you have to get what you want. And using what you have is to amend the positions of the law to ensure that you have an upper hand or create a level playing field. So basically, the moment you amend the constitution and say every political appointers should resign their office before voting. You see, it is very specific. Voting or being voted for at primaries. Because, yes, it is very specific at primaries, because it is targeted at the nomination process, not for election. And so not to contest, not to stand for election. So, and that's why it becomes very, that's why it is very easy for people to detect the flaws in the process, because it has to do with, candidature of the party. So, but if you now ask them to go and find a way to resolve or to amend the constitution, that is like asking the camel to pass through the eye of a needle.
That's in their party, you mean?
Yes, which would be a very difficult one for them. What I think should happen is let the law be amended to at least, restrict the delegates, restrict those that should resign. That, for example, the ministers can stay, but every other appointers like the essays and all of those cannot stand or vote during party primaries.
For me, I think the most important thing is why should an essay, for instance, be a statutory delegate? It just doesn't make sense. So they should try to change that in their political party, because it doesn't make sense to have an essay, special advisor, and all of that to be statutory delegates of during their convention or congresses.
These are people who. But before I go there quickly, let me. If you remember, this fight started with direct or indirect primaries. It started with direct or indirect primaries, and when that direct or indirect primaries issue came up, it was also because the lawmakers also wanted a situation where they will have more people from their constituency or from their senatorial zone participate in the primary. So when you have a direct primaries, all members of the political party from your zone will all troop out and vote as if it's election day.
Yes.
Just the same way the governor's people also will troop out and vote. So there are no statutory delegates or no statutory delegate. Every member of the party participates in the process. Where that failed, that was when they now came up with the issue of, oh, look, let us remove those people that will give advantage.
Well, did that fail? It actually didn't fail. It's just that it was concluded that indirect should be added to it as well. And of course, it's normal that you would expect that most of them would embrace indirect.
Exactly. So, and now embracing indirect, they now have to add a clause. So if it's an indirect primaries, you must resign your office for you to participate in the primaries. But otherwise, if it's a direct primaries, everybody can participate. You don't have to resign your office to participate in a direct primaries anyway. So, except you are contesting for the office. So the issue here is, I think they should look at all of this, find a common ground. Let's find a way where, you don't have to, have this, like you have said, have all of these crowd employed or employed by one man, that is the governor, voting in the primaries, because there's no way you're going to create a level playing field when you have one man who dictates the tune for almost half of the delegates at the local government and also at the state level, except when you get to the national level.
And it certainly wouldn't be tidy to say, look, as a minister, you want to take part in your party's congresses or convention where a candidate will be nominated. You just have to resign. You resign just to take part in a congress or convention where a candidate will be nominated. So you have to resign. So after resigning, do you go back? That's somehow not tidy.
Yeah, for you, because as a minister of a political party at that level, I think it will, if you do not have a stake or the opportunity to participate, you have a stake in the party, but yet you do not have, as a stakeholder, you do not have opportunity to vote for a candidate that will fly your party flag except you resign. I think that will not be fair. Also to that minister. It won't be fair. So that is why I think that what they should be talking about is restricting the numbers of those people who should resign during primaries, or create an opportunity where the lawmakers also will feel secure and fair in during the party primaries. Otherwise, we're consistently going to have this battle, and the lawyers will be having a field day because when I say lawyers, not necessarily the senior advocates, let me use that word. The senior advocates will be having a field day because this election period and this is their time.
Yes.
You see,
it's also your time anyway. It's also your time.
Yes, it's our time. The crumbs falls to us, and then
come on, Liberals. Don't worry. Your senior advocate is on the way. So you'll join that club.
Amen. And so when we get there, we will all join the club and begin to
enjoy the spoils, huh?
Yes. But then, really, we must advise our politicians that it's not, it's not everything that you will quarrel about. There are some things to sit at the round table and find a way to resolve it.
All right, Liberal Soshoma, thank you very much for joining us on the program, and thanks for your time.
Always my pleasure.
All right, we'll take a short break now, and we'll be right back. Stay with us.
Opinions are free, facts are sacred, but truth is universal.
How, in practical terms, can we, for instance, de-escalate the tension?
President must see himself as the President of the Federal Republic.
We know where the enemy is. 3 places. The Lake Chad Basin, the border area between Nigeria and Cameroon, and then the Sambisa Forest.
On DEJI360, we give you a complete dose of everything. Opinion, facts, and undiluted truth.
I hardly believe what politicians say in this part of the world.
A new Nigeria is possible, a future is possible.
We delve into the issues, dissect it so that you can understand it, use it to take action.
I don't think there's any need for any governor to look for grant for ranching.
DEJI360, dissecting the issues.